When reviewing an application for a sentence reduction, can the Appellate Division require more than the statute requires? To find out, you have to read People v. Baldwin, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of People v. Baldwin. This can be found at 2023 New York Slip Opinion 01467, published by the Court of Appeals on March 21st, 2023, the same day as another case that deals with a similar issue, People v. Ba, which I reviewed in a separate video. The issue here is the standard by which the Appellate Division has to judge applications to reduce sentences in the interest of justice as unduly harsh or severe. The law you have to understand to appreciate this case, and this is the same law as we discussed in People v. Ba, is CPL, Criminal Procedure Law, 470.15, sub 6, which says that the Appellate Division, which is the intermediate appellate court in New York, has the discretionary authority to reduce a sentence if it finds that it's unduly harsh or severe, even though it's legal. The facts in this case, they don't really get into what these substantive facts are on the ground, but basically what's been going on is the Appellate Division 3rd Department is alleged to, over a series of cases, over several years at least, been requiring a showing of applicants under CPL 470.15 sub 6 of extraordinary circumstances or abuse of discretion to exercise their interest of justice jurisdiction to modify a sentence. So the 3rd Department's been requiring not just that they review it for unduly harsh and severe, unduly harsh or severe, they also have been requiring extraordinary circumstances or abuse of discretion showings. And basically the defendant here appealed one of the cases that he had in May of 2022, arguing the 3rd Department has been applying the wrong standard. And basically the holding by the Court of Appeals is that it's moot. It's moot because the defendant already served his time. And in particular, they note that since this appeal, since the Appellate Division 3rd Department has been notified about the appeal pending in May of 2022, they've stopped doing that. They say that they have, to their credit, the Court of Appeals says, has fixed the problem. They're no longer talking about abuse of discretion or extraordinary circumstances. They are now using the unduly harsh and severe standard. So that is the correct standard under CPL 470.15 sub 6, and no Appellate Division is allowed to apply any further or different or heightened or a lower standard. It's basically discretionary in the Appellate Division's discretion. Too Long Didn't Read, 5 minutes or less, People v. Baldwin. Have a good night. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.